Hello, UCAR. Peter Christensen here, coming to you from the CEO's desk. We're going to keep talking about the seller's property condition disclosure, which has been revamped, updated, and reformatted. Again, don't be afraid about its new length. It's mostly reformatted. Okay, I want to talk about one scenario specifically that jumped out at me as I was looking through it, trying to decide what to talk about today. And that is section 6 and 7. They have to do with water. Now, remember, water is a crazy thing in Utah because it's very complicated in rights to water. And so 6 just deals with what's your culinary water, right? So mark that. We're not going to focus on that too much. But 7 is your irrigation / secondary water source. Now, it's great information. It's a lot of the information that we want to know. You know, what is the source, name of the company providing it, and is it a share? Is it, do you have a copy? So it's all a lot of clarifying information, which is a theme to the reformat of this form, is clarifying. So yeah, before it may have asked you and you marked yes, but didn't give a lot of details afterwards. So this is great information. Remember, though, that the REPC, the contract, still controls what water goes with the property. And remember further that in the REPC, the default is all water that services this property comes with it automatically, unless excluded in the contract. So that's where you're looking at section 1.4. You need to very specifically exclude what water is not coming with the purchase. So you can have a well, irrigation, shares, water rights to a stream, culinary water from the city. You can have all these things pertaining to one property, but seller may not be selling all of that with the purchase, with the property. So make sure as a seller you're excluding appropriately what's in there. So then what do you do with Section 7 of the REPC? Well, as I've talked it through, I'm not sure we really contemplated this on the Forums Committee, how that would be filled out if the water right was excluded or the share was excluded. So, there may be some times where there's actually some sense to still fill it out because maybe the water, there's piping that still runs through the property. Maybe there is some issue to let them know I have had problems with the water system, even though I'm not transferring the right to that. The system has had problems in the past. And so there may be some sense to still fill that out. But what we don't want is confusion. We don't want the buyer reading the disclosures and seeing that they filled out all this stuff about water shares and rights that are excluded, but thinking, oh, they wouldn't have filled it out if they weren't including those. Remember, the contract still controls. And this is the property condition disclosure is not amending the contract. So look through it, but remember to always check the REPC. That is the controlling document. That will tell you what water comes with the property. So even though there may be helpful information in the disclosure, the REPC still controls. So always look to that. Seller, don't forget to fill that out and make it very clear what water is excluded from the purchase, and you should be good to go. There are a lot of experts out there that can help you, attorneys that focus specifically on this. So it is a crazy, unique body of law. Remember, this is not legal advice. This is legal information only. If you need specific legal advice, please contact your attorney or some great, awesome water law attorney. And thanks for tuning in.